參加。
Thank you, members, for staying on, and I'm grateful to the representatives from the Law Reform Commission. Please refer to paper CB bracket 4, 1255/16 to 17 bracket 05. Another paper is bracket 06. First of all, I'd like to give the floor to the Chairman of the Law Reform Commission, as well as the Secretary for Justice, Mr. Rinsky Yun. Thank you. This is the 5th time that I come here as the Chairman of the Law Reform Commission to report to you about the progress of the implementation of the LRC's recommendations according to the reporting mechanism by the panel in 2012. As the SJ, I'm concerned about the need that our laws are sort of up to date, and we hope that we can take forward the work of law reform. Myself, the Chief Justice, as well as other members of the LRC, do attach a lot of importance to selecting the right topics for the LRC to study. On my part, I've always been doing this on a continuous basis. That is, we need to ask departments to understand that it's important to take into account the recommendations of the LRC and implement the recommendations. I'm sure you have already received your paper, and we have given information in a tabulated form. That is the proposals that have been implemented in full, in part, etc. Altogether, 65 reports have been published. Please move closer to the microphone. Sorry, SJ. The LRC has issued 65 reports covering civil law, criminal law, as well as other procedures. Among the 65 of them, one didn't recommend any change to the law. For the remaining 64 reports, some of them have been implemented in full. 35 of them, they have been implemented in full. In other words, 54.7% of the 64 reports. That's the first category. As to the second category, we have got 8 reports. In other words, 12.5% of the 64 reports being implemented in part. Third category, we have got 16 reports where the proposals under consideration or in the process of being implemented, accounting for 25%. And then the fourth category, we have proposals rejected outright by the government, and there are 3 such reports. That is 4.7% of the 64 reports. And then the government has indicated that the government has no plan to implement the proposals at this juncture. There are 2 such reports. In other words, 3.1% of the 64 reports. Therefore, I can sort of inform members that among the 64 reports, for those that have been implemented in full or in part, there are altogether 43 of them. For reports not accepted by the government, 3 of them. For reports which will not be implemented at this stage, 2 of them. And then for the remaining 16 of them, they are being taken up by the relevant bureaus or departments. They are being considered, or they are actually in the process of being implemented. Some reports have not yet been implemented, but since the last progress report, we have seen positive improvement. Say, for example, we have relied on legislative amendments to implement certain recommendations. Say, for example, we have the Companies Winding Up and Miscellaneous Provisions Amendment Bill 2015, and it has come into operation on the 13th of February 2017. And in fact, this is about the report on insolvency part 3. And then we have also got the Arbitration and Mediation Legislation Third-Party Funding Amendment Bill 2016 that has been introduced into the Legislature. This is to respond to third-party funding for arbitration report, and it was passed on the 14th of June 2017. And then in 2009, we have the hearsay in criminal proceedings report, and we released a consultation paper on the Evidence Amendment Bill 2017 on the 21st of April 17, so as to seek the views of the public. The consultation period will end on the 31st of July 2017. Depending on the findings, it is our plan to introduce the relevant proposed legislation into the Legislature in the 2017-18 legislative session. In addition, a number of other reports will also be turned into a draft bill. Say, for example, we have the Guardianship and Custody report, March 2005, and then another report concerning jurors, and then enduring power of attorney, and then in 2012, in February, double jeopardy report. For the LRC, we attach a lot of importance to the recommendations in the LRC reports, and we want to know whether they will be effectively implemented. Since 2013, implementation progress has always been included on the agenda. And secondly, we have been liaising with the policy bureaus and departments so that they will tell us about the progress of the implementation.
In order for the public to understand the progress of our work, all this information has been uploaded to our internet website. I will continue to work with the LRC members, the legislators, and other panel members to monitor the implementation. Lastly, I'd like to take this opportunity and thank this panel and all Legislative members for their support in law reform work. Thank you, Chairman. Thank you, Secretary for Justice. Next. I think just now we had the bar and the law society representatives, but they're not here now, so we can open it up to members. Mr. Fernando Chung, thank you. I'd like to thank the LRC for their work over the years. We need to move with the times. Our law reform work is proposed by the government. That's for the majority of cases. We are restrained by a basic law, Article 74, and the LRC being a government-appointed consultative body, they have an important role in law reform. But the pace is very slow, even though the Secretary said that half of the LRC reports have been implemented, but we still have a significant portion that are still in consideration, and the number of suggestions and reports are very limited. So even though the Secretary said he mentioned guardianship and custody, that had been proposed since 2005, and it has 4 components, and you're only dealing with one portion. And medical instructions are an important part of livelihood when we're still in just the consideration stage and the proposal stage. I'd like to ask, could we have more resources? I understand the LRC should maintain a distance with the government. They need to represent the public. So the LRC should be made up of laymen. I agree with that. But there is a very obvious lack of support in the LRC. Could we enhance the scale of LRC and increase the capabilities of this LRC Secretariat and accelerate its work? I think the LRC could expand, could double its size and still not catch up with the times. So the Secretary of Justice, in the new term of government, would you be interested in accelerating the work of the LRC and also increase its resources? Secretary? Thank you, Mr. Chung, for your question. The issues highlighted by Mr. Chung are part of the unique characteristics of our work. In other words, staff, we do have staff constraints. So aside from the staff from DOJ assisting the LRC, the rest are volunteers. So even if we seek laypersons from the social welfare, for example, they're still volunteers. In this panel, I had mentioned a few years ago, some people had raised the point that the LRC composition, should it be reviewed? I am very concerned about this issue, and I can tell Mr. Fernando Chung that when we last convened the LRC meeting, in our last LRC meeting, this LRC Secretariat had done some preliminary studies regarding how we could reform the LRC, and it was made it served as a reference for LRC members. So after compiling their views, we are now further amending the document, and in our next LRC meeting, if all members agree on the contents of the paper, we would like to see how we could promote our work. In this process, we have made reference to other jurisdictions and their experience. So Mr. Jung's proposal is one consideration possibility. Well, thank you, Chairman. In that case, I'd like the LRC to submit their report to the panel. It's just an opinion, right? So when they submit their report, we would like to facilitate the reform of the LRC and increase their resources so that they can accelerate their work. Next, Mr. Junius Ho. Thank you, Secretary, for your report. It has changed my view of your work, because our previous report said that your work was slow and was lagging behind times. I'd like to echo Mr. Fernando Jung's comment. That is, if we don't have enough staff, can we fill out the ranks? Could we step up? Could we accelerate the pace of work? Since we already done a study on, and we have some proposals, so why do we still lag behind? So maybe adding staff could deal with that. We can narrow the differences. We also heard people say that law reform has to move with the times. If we lag behind, it's less than ideal. So when we were discussing legal issues a decade ago, and if the Secretary of Justice had agreed, why haven't we implemented that? I want to talk about item 38. That is the debt collectors regulatory regime. Some matters deal with privacy. From 2002, I've seen that being dealt with. Why did I mention that? It's because I was a member of that group, and we had suggested that debt collectors, we should license that work, and up till now, we still don't have a licensing regime to regulate that behavior. And I see people, there are some illegal debt collecting or inappropriate debt collecting behavior. Why do we lag behind? So could you divert some attention to that matter? Another matter being considered is adverse possession. That is similar to item 59, but adverse possession, it affects a lot of landowners in Hong Kong. So how do we amend that ordinance since we have an LRC report, we should be given some direction. So if DOJ feels that that can be implemented, we can deal with the problems arising out of adverse possession. It doesn't matter what the direction is as long as we're moving ahead. So I just want to raise these two specific issues. SJ, thank you, Mr. Ho, for your questions. First of all, as chairman of the LRC and Secretary for Justice, I agree with Mr. Ho's viewpoint that the law needs to move with the times. Otherwise, it's less than ideal. Mr. Ho raised specific issues. The first, item 38, to debt collectors. As Mr. Ho said, some of it deals with privacy and has been dealt with, and I understand the Security Bureau, they have looked into this, and they've noted that debt collecting, initially we had some serious problems, and there have been some changes over the times, and the Security Bureau has been following this. I can communicate with Security Bureau on this matter. Similarly, item 59, adverse possession. So this is also a very controversial matter. The law on adverse possession, what extent should the law reform go? My understanding is that different sectors in society have very differing views, and we will continue to communicate with Development Bureau. In our Hong Kong land laws, adverse possession is a significant topic, especially in New Territories land. If there are some disputes, we see that very frequently. So we can continue to follow up this with the Development Bureau. Well, in our panel we had discussed adverse possession. I'd like to ask, some items not listed in the paper. I heard that the archival law has some progress. I'd like to understand to what extent have we followed up on that, and I also feel that the LRC should increase its resources. In fact, could we recruit some full-time staff, and when you outsource it to volunteers, these are very important and professional, very detail-oriented work. we need to recruit professionals. So if we increase resources, who can help LRC provide the detailed suggestions, I propose that you're now using volunteers. We understand it's difficult to find good people. So if you can take on board our suggestion that if you can divert more resources, so we need some selection criteria. We need to find experts. I understand some proposals will not be accepted. Some some controversial matters are being considered. There might not be a consensus in society. So some work progresses faster and some slower. But if there is already a consensus, then I think you need to really step on the gas, especially commercial disputes, livelihood issues, rights. You need to focus your resources on that, and you need to consider why or where what leads to some controversies. You have to look into labor disputes and even political disputes. Secretary, thank you for the question. On the archival law, there is some progress because, there are some legal issues and administrative matters and public policy issues. So my understanding is there is positive progress, but at this point, can we give a definite timetable? My understanding is we have communicated with the archival law reform chairman. They cannot give a timetable, but they understand the society's concern and they will complete their work as soon as possible. Could I ask that, are they all volunteers? I should put it this way. In each law reform topic, when we decide to work on it, so aside from the summary procedure, we will convene a subcommittee and we can divide it into two parts. The chairman and the members, they will be outside of the government. There might be some government representatives to facilitate communication or to explain government policy.
So for members who are outside of the government are all volunteers, but our secretariat will provide the relevant support, like secretarial support when meetings are held, and then when research is carried out, again we do provide support for the LRC secretariat. As far as the provision of research is concerned, all the time they have been doing a very good job. That's my view. And over the past few years, chairman and members of the LRC and the subcommittees have got this feedback from me, and they've all been very, they have all got high recommendations of the secretariat. But of course, if we get more resources, and it would mean that perhaps we can do more research or we can get it outsourced. We did at one stage consider that for some topics, if it is a more focused area, or it is merely a legal point, then perhaps we can get the academia doing it for us. In overseas countries, some of the LRC counterparts, they have a closer relationship with the universities. But of course, their model may not be the same as that in Hong Kong. Earlier on, when I replied to Fernando Zheng's question, I did say that at the last meeting, there was a paper on ways to change the procedures of the LRC, the operation of the LRC. Perhaps we can think of having a closer relationship with the profession and with the academia. Fernando Cheung has asked for the paper to be released. Once we have entered a mature stage of discussion, we'll be happy to provide the information papers to you because we want to benefit from your input so that we can know how the work can be taken forward. So your views will be of great benefit to us. Next, Mr. Elvin Young. Thank you, Chair. I can understand the difficulty faced by the SJ. Within the LRC, we have got volunteers. Perhaps the LRC's operation itself should be reformed as well. And to be fair to them, we don't see the reports being dragged on till the cows come home. Say, for example, 2 weeks ago, we passed the third-party funding bill. It was in year 2013 that they first started to take it up. And so in less than 4 years' time, we were able to pass the waterfront law, that is the Arbitration and Mediation Legislation Third-Party Funding Amendment Bill 2016. So I want to know whether it is a matter of the LRC encountering a lot of technical difficulties, or whether it is a matter of the will or lack of will on the part of the government for class action. It was first started in 2012, charities 2013. The reports were published in such years. We are encouraged by the success in the form of some reports that have been implemented. We want to know whether we can draw any lesson from the successful implementation of the recommendations in some reports so we can apply them to other reports. SJ. Well, the pace of implementation of the recommendations in the report will be affected by a host of factors. Mr. Elvin Young referred to the example of 2 pieces of legislation, one on arbitration, the other on third-party funding. As to why we're able to implement so quickly, personally speaking, I think it is a matter of lack of opposing views, and more than that, the profession would very much like to see that done. And if we look around, we know that our Asian neighbors have already done some of the work that was proposed in the reports. And then for the 2 bills involved, they were merely technical, legal technicalities without any political element. On the other hand, sometimes when we embark on a research project, and perhaps we are not politically sensitive enough, and sometimes when the LRC starts on a project thinking that it is purely something legal, but then when the report is published, the community's reaction has surprised us. For example, I didn't take part in the LRC work on charities. At the time, the members told us that when they attended the waterfront consultation sessions, or when they came to the Electrical, they felt that they were totally unprepared for the feedback or the response. It isn't a matter of who's right, who's wrong, or who's to be blamed for politicizing the topic. I just want to point out that the society may have very different views. And sometimes we may want to change the criminal procedures. Sometimes we may think that it is something purely legal. But then when the proposal is published, the police, the welfare sector, the women's sector may react very strongly, and they may have very different views, and it is difficult to arrive at a consensus. Other than providing the resources, the role of the government is sometimes controversial. And my personal experience in the past few years was such that if we would like to reform the work procedures of the LRC, perhaps we should make sure that at the initial stage of our research, we have got the participation of more relevant departments and bureaus. In this way, we can enhance our dialogue and communication with the government departments. And then, if the government has any queries or concerns, the LRC will be aware of them much earlier. Otherwise, the LRC reports will be perceived as looking at the legal aspect only, without taking into account what's happening on the ground. Recently, there was this report about gender recognition, and in this case, it was a matter of communication with the various stakeholders, and at least the report has been regarded as more objective, more comprehensive, though at this stage I don't know about the ultimate outcome of the consultation. I would like to thank the SJ. I would like to thank the colleagues from the LRC. For the past few years, the LRC has actively responded to our comments. We do see a progress, we do see improvement. So I need to praise you for your good work. Now, it is not easy to see that we are backing your call for more resources. Just now, the SJ has mentioned, and I fully understand, because I have the experience of being a member of advisory bodies like the bilingual law drafting committee. The secretariat work is very adequate, but then for LRC, perhaps you can recruit somebody on a short-term basis to provide additional help to you. Yes, the volunteers are really committed. They are very interested, but they may not be able to spend so much time on the task like a full-timer, and sometimes they may omit certain points. So perhaps you can try to set aside more resources and try to get more full-time assistance. Well, for the LRC topic, I think we can wrap it up here. So thank you, members. We have got one other minor topic to deal with on our agenda. So thank you, SJ. Thank you, SJ, for coming here for 2 items. We have had thorough discussion. I'm sure members will continue to give suggestions to you both on legal education training as well as the LRC work. Thank you. Thank you, Chair.
下次你要諗清楚，7點半你就走晒，所以會唔會即係縮 ？Hello， 下次咧，不如係咁，係好。咁咧，而家咧，我哋係想
Well, I would like to invite Mr. Laurie Low from the Home Affairs Bureau to join us. Paper for CB bracket 4 1255/16 to 17 bracket 07. This is about the proposal to write off an irrecoverable judgment debt owed to the government by a former legally aided person. So the government would like to consult our views on this matter. And first of all, I would like to give the floor to Mr. Laurie Low. Thank you, Chair. As you have mentioned, our proposal is to write off an irrecoverable judgment debt owed to the government by a former legally aided person. As to the total sum involved, inclusive of interest, it is $663,532.91. As to the background, in August 1995, the legally aided person was granted legal aid to claim employees' compensation (EC) and common law (CL) damages for injuries sustained by him during an accident at work. And then, according to Section 18A of the Legal Aid Ordinance, the Director of Legal Aid is empowered to recover the Director of Legal Aid's first charge that covered the legal costs for both EC and CL cases from the damages recovered by the AP in the CL claim. The aided person was able to get damages in the common law case, but then when the interim payment was given, the case officer forgot to retain sufficient funds to cover the total legal costs. And as a result, we have to take legal action to recover the shortfall. The LAD has discovered the overpayment. We referred the case to the DOJ to recover the money, like applying for a court order. The DOJ has tried to locate the AP, but to no avail.
So all the statutory demand on the AP person had expired, and the government had already exercised all its powers to recover the funds, and was unsuccessful in doing so. So now, upon expiry of the time limitation, and we can only propose to write off the amount. But in order to provide similar incidents from occurring, the Legal Aid Department has taken a series of measures, including staff being reminded of appropriate work procedures, and LAD also enhanced its computer system to prevent overpaying the legal aid applicants. So if this write-off is approved, we will seek approval from Finance Committee, and we now can take members' questions. So first of all, we have to thank the Secretary. I think the question now, the question is, you cannot recover the funds because of the expiry of the time limitation. So how do you ensure that funds will be recovered before the expiration of time limit? Well, on this incident, it wasn't that we were unsuccessful in covering the funds within the time limitation. Rather, it's that the compensation to the legal aided person, we should first of all set aside funds for. We need to retain sufficient funds to cover the legal costs, the total legal costs of both the EC cases and CL case. We need to provide training to our staff. We need to remind them when we have new colleagues. We need to ensure that they know how to deal with these cases. On the system, we have upgraded the computer system. There are some automatic reminders such that the staff don't repeat the same mistake I'll defer to my my LAD colleague to see if there's anything to add. Just now, the Deputy Secretary had explained that this incident occurred in 1998. Back then, we didn't have such a comprehensive system. In our current system, when an applicant receives compensation, the money gets submitted to the LAD, and we will make an estimate on the legal costs. And if we would like to give compensation to the applicant as soon as possible, but if the authorized amount is more than the legal costs, they cannot do so. So the system will stop that full compensation being from being given to the applicant. It was very unfortunate that there were two cases being conducted at the time. There was a labor compensation and employers compensation case, and the colleague at that time was only working on the common law case, and they had overlooked the employees compensation case, and the legal costs had to be borne by the applicant. And there was a handwritten note on the file, and over time the handwriting might have been obscured, but now with the computer system it will be blocked. Thank you. So I want to ask, in the past, how many of these scenarios occurred? In my term, we only have this case, but in the past, have we had irrecoverable costs? Do we have any statistics? Well, if the costs had to be submitted to FC, we had paid more. As far as I know, this was the first occurrence in the LAD, and I hope it's the last. Well, just now, this Deputy Secretary mentioned that how much there's a threshold, and if it exceeds a certain amount, you have to seek funding from FC. What's that threshold? According to FC rules, the authorized person, if there's a loss of public funds or resources, the threshold is 500,000. But this case had exceeded 500,000. That's why we need to submit it to FC, and before that we need to get the opinion from the AJLS. So this is the first case exceeding 500,000. What about not exceeding 500,000? That you didn't have to go through FC, and we had a similar oversight, and we needed to write off. Do you have statistics? I can answer based on my memory. We implemented the new system in 2002. It automatically blocks compensation from if the legal costs exceed the compensation, they cannot release that. So it's very safe. I understand. So after 98, technically it's not possible to have this matter occurring again. Is that correct? I haven't seen any cases since we implemented the new system in 2002 because they cannot release the payment. Well, regarding this item, we have a clear discussion, and as the AJLS panel, we need to urge the LAD. Now, of course, it was 98, and you weren't responsible at the time. We hope that this doesn't occur in the future. We agree submitting this to FC, And I also like to get on the record that in the system, in our staff, the staff that deal with money, they need to have clear guidelines, and technically we need to have an effective way of preventing this from occurring. So I think that would conclude this discussion. Thank you for attending. And we have to thank colleagues working with us. Thank you, Chairman.